This is a question on Representation of People Act. This question has three parts. First is discuss the procedure to decide the disputes arising out of election of a member of parliament or state legislature under the Representation of People Act 1951. Second part is what are the grounds on which the election of any returned candidate may be declared void? And third is that what remedy is available to the aggrieved party against the decision. Next is refer to the case laws. It means we also have to mention some court cases relevant to the question. Let's see the answer. First part is about procedure to decide election disputes. According to Section 80A of Representation of People Act, in case of dispute in election of a member of parliament or state legislature, the election petition can be filed in High Court of the concerned state. Election petition can be filed by a candidate who contested the election or by any elector. Any elector means by any voter of the constituency. Such petition should be entered in High Court within 45 days from the declaration of election results. According to Section 86, subsection 7 of Representation of People Act, High Court should preferably dispose of election petition within 6 months from the date on which it was filed in the High Court. But in practice, this does not happen. Trial of election petition hangs in court for several years. Next part is grounds on which election of any returned candidate may be declared void. Void means invalid. किन ग्राउंड्स पर एक इलेक्टेड कैंडिडेट की इलेक्शन को इनवैलिड डिक्लेयर किया जा सकता है? See, in Representation of People Act, the returned candidate mean candidate that has been officially declared elected. According to Section 100, subsection 1 of Representation of People Act, High Court may declare the election of a returned candidate void if court is of opinion that on the date of election the returned candidate was not qualified for the seat as per constitution, that any corrupt practice has been committed by the returned candidate or his agent with the consent of returned candidate. Now, what are the corrupt practices? Corrupt practices have been described in section 123 from subsection 1 to subsection 8 of Representation of People Act. These include bribe to voters, appeal to voters on ground of religion, caste, etc., promoting hatred or enmity between different communities, obtaining assistance from government offices, booth capturing, etc. The election of a returned candidate may be declared void if nomination of any other candidate was improperly rejected. The election of returned candidate may be declared void if the result of returned candidate has been materially affected, number 1, by improper acceptance of any nomination, by any corrupt practice in interest of returned candidate, or by improper reception, refusal, or rejection of any vote or reception of any vote which is void. Now, the next part of the question, remedy to aggrieved party. According to Section 116A of Representation of People Act, if High Court decision goes against the returned candidate mean elected candidate, that aggrieved candidate can file an appeal in Supreme Court against the order of High Court. Such appeal should be entered in Supreme Court within period of 30 days from the date of order of High Court. Supreme Court may, depending on the case, stay the operation of order of High Court. Next is case laws. Let us see some court cases relevant to the question. We will briefly explain two cases where election of returned candidate was declared void on the basis of Section 100 and Section 123 of Representation of People Act. First is Jabbar Singh versus Gendalal case. Jabbar Singh had won election by just 2 votes. In this case, on re-examination, it was found that there was improper reception of votes in favor of Jabbar Singh. So this was a case under Section 100, subsection 1, clause D, subclause 3 of Representation of People Act 1951. Therefore, the election of returned candidate, that is Jabbar Singh, was declared void. Next is very famous case of Raj Narayan and Indira Gandhi. In 1961, Raj Narayan contested election against Indira Gandhi from Raebareli constituency. Indira Gandhi won this election. Raj Narayan filed a petition in Allahabad High Court alleging that Indira Gandhi misused government machinery and resources to win this election. The court held that Indira Gandhi was guilty under Section 123, subsection 7 of Representation of People Act. The election of Indira Gandhi was declared null and void, and Indira Gandhi was barred from holding any elected office for a period of 6 years. Elections are the lifeline of Indian democracy. Representation of People Act has played important role, but it still needs amendments to check the use of money power, muscle power, and polarization of voters on the basis of caste and religion to make it more effective.